Lordship.
Lordship, I mentioned item number 4.
Item number.
Lordship, I'm filing my affidavit today, Lordship.
Okay.
I've already informed the petitioner counsel, Lordship. So
Okay.
if the matter can be disposed.
18th of April, Lordship.
Huh?
18th of April.
18th.
Yes, Lordship. For final
Yes,
disposal.
counsel is from Delhi.
Okay.
So if matter-
It is you are for
respondent number
3.
3, Lordship.
It is submitted that the respondent number 3 has filed an affidavit in opposition
Today.
today. Same is not on record. Registry to verify and take the same with the record. List this matter on
18th of April, Lordship.
18th of April.
Lordship.
Obliged.
Interim,
Okay.
any interim order?
No, Lordship. Lordship, I beg to mention item number 2, Your Lordship.
2.
Yes, Lordship. On behalf of TB Jamir, Lordship,
Okay.
the petitioner, to file affidavit and reply, Lordship.
Okay.
So, currently this may come after 3 weeks. Item
You
number
have
2.
taken consent, na?
Yes, Lordship.
On the
Yes.
prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 2 weeks.
Lordship, yes, an interim.
Interim order pass area shall continue till the next date of listing.
Lordship, I can beg to mention item number 3.
Yes.
On behalf of the counsel for the petitioner, PB Paul, Lordship. Lordship, here we have taken the consent from the other party. So, kindly let this matter come up on 16th of May.
16th of May.
Yes.
Okay. On the prayer of petitioner, 16th of May. Interim order pass earlier
Yes.
shall continue till the next date of listing.
Obliged. Lordship, I can beg to mention item number 41, Your Lordship. On behalf of the counsel for the respondent.
Please, Your Lordship.
41.
Yes, Lordship.
I'm the counsel for the appellant.
Okay.
But during the pendency of this appeal, the appellant, they have approached the Honorable Supreme Court for transfer of the petition. So Honorable Supreme Court has passed an order direction for stay of this present proceedings.
Okay. This is item number
41.
41.
Yes, Lordship.
Yes, testamentary appeal.
Okay. Okay.
The operative portion is
Yes.
page number 2.
It is the on and transfer petition being preferred by the petitioner.
Yes.
Petitioner. The petitioner before the Honorable Apex Court within bracket transfer petitions civil number 331/2024 bracket close. The Honorable Apex Court under its order dated
14 to
14/2/2024, the further proceeding of the present criminal present
testamentary appeal.
testamentary appeal has been is stayed. Accordingly, the registry to list this matter after disposal of the transfer petition civil number 331/2024.
Much.
Obliged.
May I please, Your Lordship?
An order of the order dated 14/2/2024 is kept on record.
May I please, Your Lordship?
If I could. This is in item number. Keep it. Huh? Yes,
Yes, Lordship, I beg to mention item number 22, Lordship.
22
Yes, Lordship, here I've received the affidavit in opposition filed by the respondents.
today.
Lordship,
You want to file reply?
yes, Lordship, I have to file it, but kindly
Learned-
allow me three weeks time.
Learned counsel for the petitioner press for and is granted 3 weeks time to file reply affidavit, if so advised. List accordingly.
Lordship, I also beg to mention item number 24.
24.
Yes,
Yes.
Lordship, here also I have received the affidavit in opposition.
Same order.
Same.
May I please, my lord, in item number 24,
Ah.
if I may be allowed to make a short submission, your
Yes,
lordship,
yes.
the matter actually has become infractious.
Is
For the
it?
fact that your lordship, the petitioners has already been terminated from the service.
Okay.
They were seeking regularization, and then their service of the petitioners has already been terminated by an order dated 12 March 2024. If I may be allowed to please, my lord.
Are you aware?
The name of the petition, your lordship will find it as serial number 1.
What was the challenge in the writ petition?
Your Lordship, not challenge. Your Lordship, they were seeking regularization.
Okay,
Yes.
they are seeking regulation.
Yes.
Now they have been terminated.
Yes, my lord.
Let me respond to it. It is submitted by the Learned State Council. Item number
24, my lord.
24. Learned Council for the petitioner that this matter has become infructuous in view of an order dated 12th of March 2024
Correct, my lord.
passed by the Commissioner and Secretary of the Department terminating the service of the petitioner inasmuch as in the writ petition, the petitioner has sought for regularization.
Lordship.
The Learned Counsel for the petitioner submits that he may be granted a week's time to respond to such
Lordship,
contest.
in that case, 2 weeks.
2 weeks.
2 weeks, Lordship.
2 weeks.
It's
Let
request.
at least he should whether he's aware or not. That
Lordship, it came out in the local Delhi.
no.
So he's already aware of it, your Lordship.
No, they are.
I'll leave it to my lord. I'll leave it to my lord.
See, he may in the meantime he may challenge this.
Yes,
No,
Lordship.
no,
Yes, your
So let
Lordship.
him have a chance, then we may take up these two methods.
Okay,
Suppose we set aside again question of revival will come. We'll see how he responds.
Lordship.
Okay.
I look like.
After 2 weeks.
I'm deeply
We'll
obliged.
respond it, then we'll see.
May I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 43.
43.
Yes, Your Lordship. My senior has some personal difficulty today, so kindly list this matter on 13 May.
13th May
Yes, Your Lordship.
on the prayer of the petitioner, 13th May.
Lordship, interim may continue.
Interim order passed, shall continue till the next date of listing.
My please, your lordship. Your lordship, I beg to mention item number 5.
Item number
5, your lordship.
5.
Yes, your lordship. Your lordship, we are yet to file a bakalatama for a new implemented respondent. of
New
three.
implemented respondent. Okay.
Yes, your lordship.
You are Mr.
CPOM on behalf of my senior.
Learned Counsel for the newly implemented respondent. Prays for and is granted
2 weeks, your
2
lordship.
weeks time to file affidavit in opposition. List accordingly.
Obliged, your lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item 31, Your Lordship. Here I'm representing the state and I'm yet to receive instructions. So kindly grant 3 weeks' time, Your Lordship.
Okay.
Item 31.
The learned government advocate Nagaland prays that she is yet to receive instruction and accordingly seeks for
3 weeks' time.
3
Your
weeks time to complete her instruction and to file affidavit.
Lordship. Yes, Your Lordship. Obliged.
Prayer is allowed, list accordingly. Any interim order? No.
Lordship, I also beg to mention item 25 to 28, Your Lordship. I'm praying on behalf of my colleague AIA. She's
Of-
yet to file counter, so 3 weeks' time may be granted.
Government,
Yes, Your Lordship.
25 to 27.
27. Your Lordship.
The
May I please, Your
learned-
Lord?
learned government advocate prays for and is granted 3 weeks time to file affidavit.
Much obliged. Your Lordship, item 40 as well, Your Lordship, on behalf of Tiba, Your Lordship, he's representing the state. This, here the pleadings are complete, so this may be listed for hearing. Item 40.
This is in the hearing only.
40.
Yes.
Oh, Your
Lordship,
Lordship, then,
For the petitioner. I have no objection. Item 40.
Pleading is complete. She says it should be
Okay,
listed
sorry.
for hearing. It is in the
yeah,
hearing.
sure, I overlook, Your Lordship. Otherwise, let it be listed after 2 weeks then, Your
Okay.
Lordship.
As agreed to by the learned counsel for the parties, list this matter after 2 weeks.
Much obliged, Your Lordship.
May I please, your lordship?
Yes.
I beg to mention item number 38.
Item number
38, your lordship.
38.
Kindly this matter may be listed after 3 weeks.
3 weeks on the prayer of the petition.
That may be accommodated,
Appellant.
your lordship.
Give a date,
Lordship, on 22nd.
22nd of April.
Much obliged.
My please, your lordship. Your lordship, I beg to mention item number 34.
Item number 34.
Your lordship, 2 weeks time be given to me.
2 weeks time to, you are for petitioner.
Yes, your lordship. For a petitioner,
Petitioner, you want 2 weeks time to do what?
for filing our affidavit, your lordship.
Affidavit in IA or what? Or additional affidavit? Yes, what about the respondent? You are for the writ petitioner.
Yes, your lordship.
IA is filed by the respondent. Isn't it? Item 34 is an IA. On the prayer of the learned counsel for the parties, list this matter. You are not aware,
Yes, Your Lordship. I have to check on record, Your Lordship.
huh? When? When? Adjournment when? Huh?
3 weeks time may you give, my lord.
3 weeks.
My lord, I'm appearing for school number 1.
Respondent
My
number.
presence may can be reflected.
Okay. Record that. Yes. Anything will leave left for to be determined in the list? Yes.
Oblige, Your Lordship.
May I please, Your Lordship?
Hmm.
I'm appearing for on behalf of the NIA for
Hmm.
item number 35 and 36, Lordship.
Item number 35 and
Hearing
30.
item number 35 and 36.
Okay. On
I
the
pray that
pre-
let the matter come up after 6 week, Lordship.
on the learned counsel appearing on
On
behalf
behalf
of
of
the
NIA,
NIA,
Lordship.
press for an adjournment, press for adjournment for 6 weeks. Prayer
I've
is-
taken the consent of the.
Prayer is
petitioners.
allowed. List accordingly.
Oblige, Lordship.
Please, Lordship. Lordship, I beg to mention item number 1. Lordship, kindly grant me 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the prior respondents.
Yes.
Thank you, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item 33.
30?
33.
Yes.
Your Lordship, notice upon respondent is still awaited.
Okay.
Allow me 3 weeks' time to complete the step through Dusty service.
You want to take Dusty?
Yes, Your Lordship.
Just wait. We'll see the file and pass the order. Okay. Just wait for something.
From the supplementary cost list for motion, item number 45.
Please, Your Lordship.
Yes.
Lordship, this incident criminal petition is filed under section 482 CRPC.
Which way notice?
Lordship. Lordship, but I have an interim prayer for staying the proceeding before the sessions judge Kohima, Lordship.
We could have passed that interim order if the informant would have a party.
Yes, Lordship, informant is a.
No, but a respondent, not as a petitioner. Heard you are?
Mika HI.
Okay. Learned counsel for the petitioner. This is an application under section 482. Assailing so and so. Full stop, comma, on the basis of and a compromise entered into between the petitioner and the informant. Full stop. Issue notice returnable after 4 weeks. Considering the nature of alleged offense as well as taking note of the compromise dated 29th of January 2024, it is provided that till the returnable date, the further proceeding in so and so shall remain suspended.
Much obliged, Lordship.
For admission, item number 21.
May I please, Your Lordship?
Hmm.
I'm appearing for respondent number 3, 4, 5, and 6, Lordship. I may be allowed 1 week time to file my affidavit. I have
After
received
the
my,
amended.
after amended, Lordship,
Okay.
I have received the instruction.
Okay.
So accordingly, the
Uh,
matter may list up to 1 week.
Yes.
My lord, I am for the petitioners.
So she wants to. The learned state council submits that she has received instruction in terms of the amendment, amended writ petition. Accordingly, she would requires 2 weeks time,
1 week, Lordship.
1 week,
Then we-
1 week time to
Have
file
received it.
affidavit in opposition. Accordingly, she prays for an adjournment. Prayer is allowed. List this matter
After 1 week.
after a week to enable the state to file affidavit in opposition.
Lordship, in the meantime, the registry may be directed to reflect my name, Lordship,
Okay.
for respondent number 3, 4, 5, and 6.
Registry to reflect name of
Respondent,
uh,
answer for the respondent number of 3, 4, 5, and 6.
person number 3, 4, and 5 in the
5
cost-
and 6.
5 and 6 in the
Lordship.
cost list.
Oblige, Lordship.
Oblige, Your Lordship.
For admission, item number 23.
Yes, who is for the state?
Lordship, and for the state, Your Lordship.
Ready?
Yes, Your Lordship.
What is the issue?
Issue lordship with regard to the premature retirement.
Premature retirement.
Yes.
On what ground?
There was some discrepancy with regard to the
Date of birth,
date of training. Date of training.
date of training.
He was initially appointed on contract and thereafter extended from time to time.
Mm.
And then at one point of time, there was some break gap.
Mm.
So in order to overcome all these discrepancies,
Mm.
government has determined a date that is 17/11/1989
Mm.
as the date of training.
Mm.
In view of so many contradicting and conflicting documents, and in absence of any extension order, there was a break.
Mm.
So by avoiding all this, they have determined the date of training on 17 November 1989.
Mm.
Going by that, the petitioner is due to retire on 30th of November 2024.
Mm.
And in all the official documents, in all throughout the service career,
Mm.
this 17/11/1989 was taken as the date of training
Mm.
in all official records.
Mm.
But then with the retrospective date,
Mm.
when the petitioner was working,
Mm.
he was served with a termination order, retirement order that you are to retire with effect from that date.
Mm.
This happened maybe because of the fact that the petitioner has filed two cases.
Mm.
One was with regard to his cadre.
Mm.
He claimed that he belonged to the secretariat service cadre, like any other employee. That was one. And another case was with regard to his promotion. The effective date of promotion that was given from the date when the DBC was held. But
No, just tell me how the date of retirement is related to a training.
yes, it's like this, Lordship.
Huh?
The state of Nagaland
Hmm.
has passed an act called Nagaland Retirement from Public Employment Act 1999. That
Anyway,
was
anyway.
second amendment.
Okay.
An act was passed. As per the provisions of the act,
Hmm.
a person will retire from service
Hmm.
on completion of 60 years of age
Hmm.
or on attaining 35 years of length of service, whichever is earlier.
Earlier. Okay.
If I attain 60 years earlier, then by age I will retire.
Hmm.
But before attending 60 years of age,
Hmm.
if I complete 35 years of length of service from the date of joining,
Hmm.
then I will retire on completion of 35 years
Okay.
of service.
Where is the impugn
as
order?
per the
Where is the
provisions.
impugn order?
Impugn order, Lordship, will find at page 68. Annexure V. Page 68.
Okay.
This is 17 August 2023. Under the provisions of the Nagaland Retirement from Public Services Second Amendment Act 2009, Shri Surjit Singh, HA, in the Office of the Advocate General Nagaland.
Now, what
Gauhati.
is their stand, government stand, how they have calculated the 35 years? Any stand in the affidavit?
From the initial date of joining on contract.
From the initial date of joining on
On
contract.
contract. That was.
Where is that? Where is that?
Page 24.
Page 24.
Annexure A, page 24.
What the service condition says? Any service rule regulating this head assistant?
No, not head assistant.
What is HA?
LDA cum typist.
LDA cum typist.
Yes.
What is their service condition? What is the rule with that governs their service condition? in terms of the service condition, there must be initiation of a service. If it may recognize a contractual service, it may recognize a regularization.
Subsequent
it may-
documents will clarify that, Lord.
Just for the initial understanding.
Yes.
See, issue is very simple. Issue is what should be your date of entry into the service.
Determining date
Ah.
for date of entry.
What
into the
should be
government service.
your date of entry into the service? This is one.
Correct.
This is one.
Correct.
Now, your entry into the service can be determined or pronounced on the basis of the service regulation. So what is your service regulation and how it was dealt? If it is silent, then we'll go to some other aspect, that precedence or something like that.
It is silent.
It is silent.
Yes. That is why we have to go as per the records,
Huh.
what the records says.
So according to you, what is the mode of appointment to this post?
That is why, Lordship, since it was an
And
appointment,
under the service rule?
yes, this is an appointment on contract.
No, it is in a contract.
Yes.
Suppose an equivalent post of LDA cum typist is to be appointed in the office of the Advocate General.
Yes.
What is the mode of recruitment?
That is, although he is posted in the office of the Advocate General establishment at Gauhati High Court, their service conditions are regulated under the Law and Justice Department.
Okay, anyway, whatsoever service regulation, as per that, what should be the mode of entry into the service?
Entry into the service should be by way of regular recruitment.
Direct recruitment.
Yes.
And where is this, how this was a contract, his service might be regularized.
Yes, subsequently, his contract service has been regularized.
And from which date?
Yeah, I'll come to that. And Lordship, at one point of time, there
Just
was.
for initial understanding,
Yes.
I'm not, I will give you a percent here just to understand.
Yes.
Now,
Now,
are we going for final disposal today?
if your
Madam?
Lordship places, yes, better, because this is with regard to retirement. So preference should be given, Lordship. Now kindly come to page 26.
Page 26.
Yes,
So this is page 24 is initial appointment.
initial appointment. This was on contract basis with effect from 26/1988.
26/8.
1988.
Okay.
And page 26 is the extension order.
Just give me a moment. Then page 26.
Yes. This is 26 September 1989. In continuation to this department's order of event number dated 1/9/1989, the appointment of Shri Sarjit Singh as LD cum typist in the office of the Advocate General Nagaland, Gauhati High Court, Gauhati, is hereby extended under the same terms and conditions till 31/10/1989. So there is no order of 1/9/1989. Therefore, in view of the break of 16 days and in view of so many anomalies, the department as well as the PNAR has accepted 17/11/1989 as the date for determination of the length of service of the
So
petitioner.
as in terms of page 28.
Yes. Before that.
So last
page 27.
extension was on 26th of 20.
Yes.
That is 17th of November, isn't it?
Yes. Page 27.
Page 28, type copy.
Yes, type copy is page 28.
So it was taken to be the date of entry.
Yes.
Now, then page 29 is the regularization.
Yes,
It says 3/3/1993.
yes.
What is this?
3/3/1993.
Why 3/3/1993?
This is this. Interim.
3/3/90. Why 3/3/1993?
Yes,
Any explanation by the state?
they have not given any explanation to that law.
So your regularization is with effect from 3/3/1993.
Yes.
So your entry into the service will be 3/3/1993. If 3/3/1993 at 35 years,
That will be beyond 2024.
that is the issue, is not it, madam? If you have regularized on that day, count the service from that day.
Your Lordship, the computation has to be from the initial appointment, Your Lordship.
Ah.
It has to be from the initial appointment and not
So
from the
then if we
subsequent
hold
extension
that,
order.
then every contractual employee will get their benefit of service for promotion, seniority, everything.
Your Lordship,
That is not the law.
And also the pensionary benefits.
Everything.
Your Lordship, the joining report, Your Lordship,
No, see. There are two aspects.
Lordship.
Issue is very limited. We need not
Yes, yes.
elaborate.
Yes, yes, Your Lordship.
Here, entry into the service means what? To entry into the service in the government form.
Lordship.
Okay, you will give a person all benefits of a government employee from the date when he becomes a government employee,
Lordship.
isn't that it? So that is, according to you, you have regularized with effect from 3/3/1993.
Lordship.
Therefore, his entry into the service is 3/3/1993.
No, Your Lordship.
Until and unless you can show under the other act that contractual service is also to be calculated for purpose of calculation of this 35 years.
Lordship, Lordship.
Where is that act? Show us.
Lordship, that. act
We
will
need not
have it
go
with
for
me
any
now.
complexities. Give
Yes,
us the
yes.
act. That act. Are you having a copy? The 35 years or 60 years, whichever is earlier. How this is to be counted? There must be some interpretation therein.
From time to time, government has issued different notifications because there has been a lot of confusion with regard to the date from which date it has to be counted.
Huh.
To my interpretation,
Hmm.
the definition of the public employment says
Hmm.
that any appointment to any pensionable public service or post
Hmm.
in connection with the affairs of the state of Nagaland and the Nagaland Legislative Assembly.
Hmm.
So it has to be pensionable.
Hmm.
The service has to be pensionable
Huh.
for
Can
computing
I
the
have a
period.
copy of that act?
I will get it, Lordship.
Okay,
It will
we'll,
come after some time.
after some time, let us finish the other matters.
Lordship.
Okay, we'll see if possible today. If not tomorrow, we'll finish it up. I think, Mr. Jamit, that is the issue. What should be your entry into the service?
Lordship.
There is a regulation order 3/3/93. Prima facie, this court is of the view that that should be the entry into the government. And contractual or other casual period cannot be counted for this purpose.
One interesting development is, Lordship, in the website of the PNR department, who is the nodal department regulating all the service conditions of the government employees under the government. Now, there they have shown 30th November 2024 as the date of retirement. That was shown. That was the date which was maintained all along. But after disposal of one contempt petition, which was filed against the law department, after the disposal of that, holding that there is no contempt, then they have changed that entry even in the website of the PNR department. Now they are displaying the date which they have issued the ambient order. So I will.
We'll come to that.
Yes. bring all this.
Let us first understand the principle, then we'll go to
Lordship.
the facts.
Lordship.
Yes, next, call the next case.
For admission, item number 28.
28, na? Yes.
Lordship,
Hmm.
the state is yet to
I'll counter
file their
affidavit.
counter.
State, who is representing state? Any counsel for the state? Yes, by which, the public works department or what? Huh? Which department?
PWD. PWD housing. Lordship.
Yes, comment, tell us. Will you file affidavit or will proceed?
Oh, Lordship, since I'm not in this case, Lordship.
Who is in this case? Are you aware? No.
No, Lordship. That view of the matter, Lordship, let it come after.
Secretary of Works and Housing Department, any standing counsel? Works Department, Public Works Department.
Lordship, in that view of the matter, let it come after a week, Lordship.
Okay, we'll just intimate the whoever is dealing with this.
Lordship.
On the prayer of the learned government advocate, matter stands adjourned for 2 weeks to enable the department to file affidavit in opposition. List accordingly.
Obliged.
For admission, item number 29.
Lordship, in this case, Lordship, I may allow some time to get a instruction, Lordship. So if Lordship.
What is this criminal petition is all about?
To what?
Learned, you are additional public prosecutor?
Lordship.
Huh?
Lordship.
The learned additional public prosecutor. Press for
3 weeks time.
and is granted 2 weeks time to
Uh,
complete his instruction.
Lordship, meantime, let the interim order may also. If there is,
Any interim order is there earlier?
if there is.
No
Because-
interim order, huh?
Is there-
There is no interim order.
Okay,
No, no, no.
No, there is an interim order. The interim order passed on 8/2/2024 shall continue till the next date of listing.
For admission, item number 30.
may I read it?
Yes.
Lordship, it is a bill application under 439, registered under section 5062 420 IPC.
Where is the FIR?
Page 10, Lordship. An actual one.
Inside?
Yes, Lordship.
Lordship, on one of the occasion, this honorable court has directed to.
It's a
produce-
case of causing.
Yes, Lordship.
Yes, give, what is the case there? Instruction.
And other cases granted bail, Lordship, in the Honorable High Court also.
No.
I have given the copies. Known ingredients of section 506 and 420 of.
To the satisfaction of?
CGM Dimapur.
To the satisfaction of CGM Dimapur. Case diary Perus, huh?
Obliged.
20,000, huh? One local surety.
Obliged.
For orders, item number 32.
dispose of, huh? LCR. LCR is awaited.
Yes, your lordship.
Discourse under its order dated 15/3/2024 call for the case record. Full stop. Office note dated 15/3/2024 reflects that the case diary were called for on 15/3/2024 and same is awaited. Not received, na? Registry to issue reminder and list this matter. Give a date as per your convenience.
Your lordship, if it can be come up on 25th of April.
25th of April.
Yes, your lordship.
25th of April.
Okay.
Much obliged, your lordship.
For orders, item number 39.
33, I think there was 33 was there, no? 33, yes, 33 was there. You can give it by this, sorry, every time you need not come. Which tell us?
Your lordship, service upon respondent number 1 and 3, 1 and 3.
1 and 2.
1 and 2, your.
Office note dated 21/2/2024 reflects that service in respect of respondent number 1 and 2 is service report, in respect of respondent number 1 and 2 are still awaited. In view of such position, the learned counsel for the petitioner prays that she may be granted,
3 weeks time.
she may be allowed, she may be permitted to take steps
Through the.
through dusty service, through dusty mode. Full stop. Prayer is allowed through registry, huh? List this matter on, give a date. Give a date after 4 weeks. Madam, if you serve a notice, at least 4 weeks time is to be given, then you'll have to file an affidavit. After 4 weeks, give a date. Notice is made returnable on, give a date after 4 weeks. 25. You take steps and file an affidavit that you have taken, effected the service.
Much obliged.
For orders, item number 39.
Please, Your Lordship. Your Lordship, this is a very simple matter raising one low point. That is whether the political assistant to DC has the authority to pass any order. And as far as the precedences set by this Honorable Court in the catena of decisions, the political assistant to the Deputy Commissioner is not authorized in law to pass any judicial order. Your Lordship, I had raised another issue, but that issue would not be necessary. The other issue is whether the district customary courts will have the competence to try the matter which is not customary in nature because the dispute arose out of a contractual agreement. But that issue, since the first issue of whether the political assistant has the authority to pass any order in law and the orders of this Honorable Court has categorically stated that the political assistant to the Deputy Commissioner is not authorized in law to pass any judicial order. So that itself will suffice, Your Lordship.
Already there are some.
Yes, precedences. I have.
What do you say?
That is one part of the story. There is always a second story, Lordship.
But if
actually-
one part damages, everything will not go to the second.
Exactly,
If,
Lordship.
if the impugn order, what is the challenge in the challenge in the order? Where is the
Past
order?
the,
Where
your
is the
lordship,
order?
it is at page 39.
An order was passed by the DB's court.
Hmm.
He has submitted to the jurisdiction.
Hmm.
He has taken part
Hmm.
and then to some extent,
Hmm.
he has complied with the order passed by the DB's court.
Hmm.
More than 2 lakhs.
Oh, that matter. I dealt it with this earlier. That some payment of
Yes,
contractual
yes.
liabilities.
Exactly,
Okay.
Lordship. And then he has already complied with the order passed by the DB's court.
Hmm.
In the late of the day, maybe it's an afterthought.
Hmm.
He is coming before this honorable court questioning the jurisdiction of the DB's court when he has already partially complied with the order of the court. And
The
this is an
jurisdiction
issue.
so much so far relating to the subject matter, jurisdiction as to the subject matter can be raised at any time.
Jurisdiction issue, yes. A
Ah.
question of law can also be
Ah,
raised.
because when an authority is not having any jurisdiction, that matter ends there.
But law permits it.
Hmm.
It's not that.
So
it's
far
not very-
relating to the territorial jurisdiction or pecuniary jurisdiction, these are different issues.
My lord.
Territorial jurisdiction, okay, both parties surrendered to the jurisdiction, they have taken part. Subsequently, that will not, they cannot raise.
Lordship,
But when it is the subject matter jurisdiction, just suppose civil court passes a judgment of on a criminal matter. That is a subject
Yes.
matter jurisdiction that will vitiate the everything. So it is void ab initio.
yes.
My lord.
But here, so far as the present case is concerned, the matter has been taken to the DC.
Hmm.
DC has referred to the DB's court.
Hmm.
And the
DB's
order
court
was passed by the
are
PA to DC.
recognized under the law
Hmm.
to try the cases.
Hmm.
Once it is referred to by the deputy commissioner.
Hmm.
So deputy commissioner
What is the challenge here?
challenges the order of the DB's court.
The PA to DC. And your lordship, if we go into
No,
the
where is the tell us the
page 39, your lordship.
page 39.
Yes, lordship. This is in Angami language, so the translation is at the next page, your lordship. Translated copy. Merit, your lordship.
Hmm.
For this case, both the parties came on dated 19/3/2019 to political assistant to Deputy Commissioner Kohima Court. After hearing the statement of both the parties, it is learned that both the parties had in partnership. This is their translation, your lordship, a little pathetic, but I may be allowed to read as it is. Take up a contract under Nabar from Boza to Pima Garipima Kizumetuma for road construction. Also, it is learned that from the parties that balance is due amongst the two parties. Furthermore, the two parties had an agreement between them to pay the dues with stipulated time and date.
How this process was initiated before Deputy Commissioner?
Your lordship, the respondent, they are the ones who initiated this proceeding against my client, the present petitioner. Now, your lordship, the story in a nutshell, in one line, your lordship.
Hmm.
Contract is for 100 rupees. They agreed to share 50-50.
Hmm.
So the other party, they insisted on another exact 50 rupees without executing the work. How can the money be divided as 50-50, your lordship? Simple common sense. So that is how the Dobashi scored, more particularly the here to DC.
Suppose
Yes.
this order passed by the political
DC.
assistant to Deputy Commissioner dated 29/5/2019
Yes, my lord.
is an original order or is an appellate order?
This is an original order.
Original order.
Yes, lordship. This is an original order. So, your lordship, if I may be allowed to place some authorities.
Who approached this Deputy Commissioner? Where is that application?
Your lordship, it was the respondents who approached.
Where is that? Anything?
So, on the basis of their complaint, we received my client received the summon.
Hmm.
So that is how the proceeding took place. My lord, so far as the jurisdiction of whether the court has the jurisdiction to try in the first place is concerned, the issue is settled. The political assistant to DC, this honorable court has already held in a catena of decisions that the political assistant to deputy commissioner is not authorized in law to pass any judicial order. So on that basis itself, though my learned senior colleague has brought another side of the picture, the basic issue is when the first.
Suppose we set aside this order, what shall be the remedy of the respondent?
Your Lordship, they have to approach the appropriate forum. And in the first place, Your Lordship, this is an issue arising out of a political, the contractual agreement. So whether the, yes,
we see the customary court can assume jurisdiction
when the issue has an issue has to do with customary practices, Your Lordship.
issue is to be customary practices or the litigants belonging to certain customs and the claim.
Of course, that issue is also there, Your Lordship. But
Because
if we go by
if the people are
Yes.
suppose so far relating to North Kasar Hills, when both of them are tribals,
my lord,
any issue can be dealt in by this courts, even contract.
there are some other decisions which I have not placed before Your Lordship today because this first issue itself is sufficient because the political assistant to DC has no jurisdiction.
No,
But
that's okay,
Lordship,
fine. Suppose
other precedences.
Suppose we set aside.
My lord,
Then what is a person cannot be made remediless only on the basis of jurisdiction. Where will the person go?
that is understood, Your Lordship. There is civil court, Your Lordship, because this honorable court has also in other decisions.
Now, suppose civil court. Civil court
Yes.
is a dispute is of 2019.
My lord,
In the litigation or wrong forum, suppose we held that this is not maintainable. In the meantime, it's a money claim barred by limitation.
no, this honorable court has the jurisdiction to, yes, my lord. But my lord, will
Then
kindly
we'll have to
appreciate
enter,
this.
then we'll have to determine that this is only the civil court. So therefore, even if we assume that on the first point, we
Lord.
can set aside this order, matter will not end. Because as a court, we'll have to look into the other side also. That what should
My
be
lord.
the remedy?
Let him approach the appropriate forum because in money suits,
Hmm.
there are catena of decisions of this honorable court where this honorable court has held that money suits, these are not something where the customary court has the competence to be able to try the issue because it requires a proper examination of the witnesses also to arrive to a
So
logical
that issue
conclusion.
also we'll have to deliberate.
My lord,
First part, okay, fine.
yes, my lord.
Assistant will not have. If assistant is not having, then that may be taken up by the deputy commissioner himself. Only it's a defect of jurisdiction by virtue of passing a judgment by a political assistant, not by the authority himself. It is not a case that this is deputy commissioner will have no jurisdiction. Is that it?
Yes.
If you say that deputy commissioner will have no jurisdiction, then we'll have to go to the second part. Is that it, Mr. Jami?
Yes. No,
So both the part will have to decide. Today, this needs regular determination. First part is fine, subject to what he says. But there is as he says, there is a second part also.
then I have to produce some other decisions also
Ah.
before your lordship,
Okay.
where even in money suit, this honorable court has held that the customary court has no competence or the know-how to be able to
Okay.
decide the issue. Yes,
If we
lordship.
go to that part, then other issue will be as regards the period spent in this court. What will be the implications of Section 12 of the Limitation Act? Whether
Lordship-
we can, here itself, we can say that this was a litigation in
When
wrong
the
forum.
Yes, lordship.
So that these three aspects you'll have to address.
When the litigation is before the wrong forum,
Ah.
lordship,
But whether we can
Yes.
pass that order here or we can give a liberty to, we'll have to make a determination. So we'll need a deliberation. We cannot decide like this. It will have a far-reaching consequences upon other cases also.
then
When?
Monday, coming Monday. What is the date? Coming Monday?
Monday will be 8, na?
Eight.
That day.
9?
9, okay. We have fixed.
Ninth will
like
give,
that.
ninth will give a try. If possible, we'll dictate here because
My
tenth
lord.
is the last court. I do not want to make
And
it
that is a
CAB.
division bench day.
Division bench is also. there.
9th is a Tuesday.
No,
No,
10th.
tenth
Last
is a
working day.
working day is
and
a
that is the
division bench. So we'll try, give a try on 9th if possible, you can
Lordship.
dictate it.
Your lordship,
But I will not keep it as a CAB.
my lord.
You just, so therefore be precise
Yes,
and
lordship.
keep ready the points.
I will, your
Okay.
lordship.
Ah.
God bless you,
So
lordship.
these are the issues.
My lord, I got it.
Ah.
Yes, your lordship.
He cannot also be made remediless.
Yes, lordship.
Suppose we felt that you know, this is not, order will go, but what next?
Yes, lordship.
If we say that, okay, deputy commissioner
So,
will have a
I-
power to
yes.
deal with,
Well-
no problem on that, this will be a de novo thing. He cannot have any objection.
If I have understood your lordship correctly,
Suppose you argue
Yes.
that no, deputy commissioner himself is not having a subject matter
my
jurisdiction.
lord.
Two aspects. One is
Yes.
subject matter jurisdiction.
Yes,
So if you argue that he's not having subject matter jurisdiction, then we'll have to make a determination that in respect of a dispute arising out of a contract, customary court will not have a right. This will have a far-reaching effect.
yes, lord.
So we'll have to make a clear determination
My
on
lord.
the basis of everything.
Then the third
What is the
limitation.
object of customary court? Under what circumstances customary court can exercise jurisdiction? Whether it is a subject matter or it is a character of the litigant. Because there are two parallel courts.
Yes.
On the
Two
second subject matter, your lordship.
two
Yes,
persons from Nagaland in certain matters can file a civil suit and through a regular court, and they can go to the customary courts also. Two parallel ways.
my lord.
So you are giving a proposition where you are saying that though there are two parallel courts, so far relating to money suit, customary courts will have no jurisdiction. This subject cannot be dealt by customary. Moment we pass this order, this will have a far-reaching consequence upon the customs of Nagaland. So we cannot pass on.
And that precedence is already there, my lord.
You show us.
I will
You show us.
show to your
You
lordship.
show us.
Yes, lordship. Then the third is on limitation.
Third is, and suppose we say that, okay, customary court, then third is the limitation.
My lord.
Because this is a litigating here and major part is pending at your behest.
Right.
You have preferred an application, it is pending. So what remedy original that section 12, whether we should pass an order or we should relegate it to the competent court. These three issues.
My lord.
But be precise, we'll have lesser time.
Second aspect, lordship, I may have to
Then-
read
then
the
we will
proceedings also.
Okay.
Because whether the deputy commissioner, that aspect I have to show your lordship how the proceeding actually
But
took
not
place.
only judgment, from this what is called
Rules for administration
Yes.
of justice in police in Nagaland.
Yes,
from that provision we'll have to see.
Yes.
my lord.
That this is excluded. It should be clear, otherwise we
Yes.
will not go by.
That is
Yes.
correct.
Oblige your lordship.
For hearing item number 42.
Yes, what is this?
May I please, my lord? My lord, this is a petition under section 482 CRBC for quashing CR case number 1/2022, pending trial before the Court of Chief Judicial Magistrate to move an argument against petitioners.
Who is for
My
the,
lord, I'm for the petitioner, my lord.
who is for the private respondent?
Yes, 234.
234. 23. Here is only 1 and 2 or 234. No?
234.
I'm for all the petitioners, my lord.
This is NI Act.
Yes,
Right.
What
is the ground for quashing?
my lord, actually, this is a contract work.
Hmm.
It arises from the contract work.
Hmm.
And there we have a tripartite agreement. And may I take you to page 26 to 28, tripartite agreement, Annex 30, my lord. There is special in para 5. It has been clearly written.
Hmm.
May I read, my lord?
Pace.
Page 28, 28.
28.
Yes. It starts from 26, but relevant portion is on page 28, my lord. There in para 5, specifically, it has stated that all disputes and questions arising amongst the party in connection with the execution of this contract work or the term and conditions stipulated in this agreement shall be referred to the arbitrator in accordance with the provisions of the Arbitration and Conciliation Act 1996, then in force.
Okay.
So this is the operative portion, relevant portion. And now here, my lord, we are executing a contract work, which has been issued. The contract has been issued to the petitioner number 1. Now I am the attorney holders. Then he is also a contractor. Then we.
So just let us
Yes.
understand, your ground of challenge is having a remedy of arbitration.
Yes, they have filed Jack bouncing case, private complaint case. And now I'm saying that there's no question of check bouncing since it is a contract work. Yes, no doubt I have issued, as per his request, 49 leaves of check. And then without date, only my signature was there. And then now we were executing the contract work. And then without my knowledge, before that, my lord, I have.
See, let us not go
Yes.
to all this.
Okay. My lord.
See, power under 482 to quash a criminal case will have to have a satisfaction that no case is made out.
Yes.
Okay. From the pair perusal, we need not go up immediately reading. We must have a satisfaction that no case is made out. Now, why are you saying no case is made out? Because that there is an arbitration clause or the dispute between you and him can be resolved in an arbitral forum. Is it your case?
That is one aspect.
And others tell us the other aspect.
Other aspect is that the check bouncing doesn't arrive at all. My
So
lord.
these are facts.
Yes.
That is to be determined by the trial court through evidence.
Yes.
Can we come to a conclusion that these checks were blank leaved, that these checks were having no dates, there was only signature? We'll have to see whether the procedure in initiating the negotiable instrument case is followed. If followed, matter ends there. Until and unless you can show that it is not cannot be a case of negotiable instrument.
Yes.
Nothing more, nothing less. We are in 482.
Yes, my lord.
Power is very, very defined and limited.
Then another aspect is, my lord, that
First aspect so far relating to arbitration clause. according to this court, that cannot be a ground to stall a negotiable instrument.
Yes.
Because these are two separate remedies.
Yes.
That part is gone. So far relating to the facts, which you are saying that I did not have any liability towards them,
Yes, that's,
is a matter of, it's a rebuttable things. Because in negotiable instrument, presumption is against you, and it is presumed that check has been issued in honor of some debts and liabilities.
yes.
This is initial burden upon the complainant. They will have to discharge this is it is upon you. If you can discharge initial burden that no, this is not a due, rather it was out of the contract and all, then it is them to prove that there is a due. That cannot be exercised before this court.
Yes, my lord, that my prayer is only that. And then other aspect is,
So first aspect gone.
first aspect gone. The other
Two
aspect,
gone.
the other aspect, my lord,
Mm.
it is that which the check I have presented, given to them. They have presented the check after nearly 2 years. Now here, the NI Act 138
That
says,
can be a ground.
yes, 138 says,
Mm.
my lord, here provision,
Mm.
clause A,
Mm.
the check has been presented to the bank within a period of 6 months from the date on which it is drawn or within the period of its validity, whichever is earlier.
Where is it? Section 138?
138 proviso A. So, my lord, I have given the check 19/3/2019. They have presented the check 2020. It should be within 6 months. And even they haven't served me a
Just a
notice.
What was the date of the check? Let us read the complaint.
Yes, my lord, I have given them the check on 19/3/2019.
Given them is not important. Important is the date of the check.
Date was not entered, my lord.
The check
I
has
have-
been presented to the bank within a period of 6 months
Yes.
from the date on which it is drawn. What
Yes.
is the meaning of drawn? Or within a period, drawn is meaning when you put the signature. So what is the date of the check?
That 19/3/2019, my lord.
Date of the check is
19/3/2019.
19.
Yes.
And this case was filed on
2022, my lord. 2022.
Yes, what do you say on this?
Your Honor, Your Lordship, I will just take you on the complaint petition, Your Lordship. complaint petition, that is.
Paragraph 5 and paragraph 4 and paragraph 6.
Yes. Sir. Paragraph 4.
Hmm.
The accused, in order to secure the payment of the complainant, finance amount issued two post-dated check
Yes.
bearing number 402707
Dated.
dated 8/12/21.
So 8/12/2021.
21 for rupees 2,50,000.
2 crore 50 lakhs.
Sorry, Your Worship, 2 crore 50 lakh.
And check bearing number so and so
so
dated 9/12/2021.
for rupees 2 crore 50 lakh.
50 lakhs.
Only drawn on Canada Bank ATP.
So it was drawn one on 8/12 and other on 9/12.
9/12, your Lordship.
Okay.
Yes, Lordship.
Now you presented it when? On 12/12/20,
On 10/12/21. Paragraph 6.
on 10/12/2021, you presented it.
Yes, your Lordship.
Okay, then.
The copy of pay and slip and bank memo.
Okay, fine,
dated
fine.
10/12/21 is there.
Now legal notice was issued when?
Yes, Your Honor, legal notice was issued on 21/12/21. Paragraph 8.
Just a minute, just a minute. Check is dated. Legal notice was issued on 21/12/21. Okay, that is also within time.
Yes, your Lordship. Now, that being highly agreed by the act of the accused stated above, the CR case was filed. Your Lordship.
Yes.
Yes, my lord, yes, concealing the fact.
See, sake was drawn on 8/12 and 9/12. It was presented on 10/12.
No, my lord, let me reply to this, if you allow me. They have served the first legal notice. They are concealing the fact. On the page 33, my lord.
No, understand. These facts cannot be determined under 482.
No, but not only two checks, my lord. 49 leaves of checks, not only two post-dated. Earlier notice, my lord, kindly come to page 33. So they have concealed this fact. Now they have used up two checks. And now here, first they have presented check for encashment on 22/1/21.
This is a very good ground.
Yes.
Before the court, trial court.
No, but
can we decide all these facts? You will have to prove this document.
No. That's why, my lord, unnecessarily they have filed. And if they want to go for arbitration, that's very much welcome.
Arbitration is different.
Yes.
Arbitration is
this is criminal act. How the arbitrator.
Arbitration is something different.
But my lord, here they have presented the check on 2021, but legal notice I have never received. It is a manufactured legal notice, and even they did not.
According to you, this was 9/8/29 legal notice was issued. According to them, legal notice was issued on when?
No, two legal notice, my
lord.
lord.
The same sake.
Yes, they have concealing the first one.
Now, what is their response as regards this document? Page 33.
They have no answer for this.
What is your answer to this?
They are concealing. They didn't even file. But second legal notice, they have never served me. I denied to have received.
That is a fact.
Yes, my lord.
If they say that they have issued first a notice, then they issued a second notice without presentation after notice, then if this is a admitted fact, then of course 482 may be maintainable.
Yes, my lord.
But what is your stand on this?
Which one, Lordship? Page 33, legal notice.
Page 33. Yes. There is another different check number.
Okay, when check was, just give me the date. When check was bounced, presented on 10/12/2021.
Yes, your lordship.
Legal notice was issued when?
21/12.
21/12/2021.
Yes, your lordship.
Then case was filed on?
The stipulated period, the case was. filed.
No, give us the date, give us the date. Twenty-one, 2022.
Yes.
21/01/2022. What should be the period? What was the date of knowledge? Where is your statement? Let us see.
My lord, the second purported legal notice has never been issued to me. But only the first one. And which I have even given reply to them.
What is this notice 9/8/21?
9/8/21, that is also the same thing, my lord. Two post-stated check. And then which,
Your lordship, I would like to clarify this, your lordship. Your lordship.
According to this notice, check was returned on 21/1/2021 and 29/03/2021.
yes, 2021.
Your lordship. Your lordship, there were 4 check, your lordship. Earlier, we have presented 2 check. So that check is not a concern matter here in this case, your lord. Earlier, these 2 checks.
402704. Where are the check numbers in this case?
My lord,
402703.
yes.
Now, here the question is the check number 707 and 706.
Just a minute. 402706. 402. 6 and 7.
My lord, here, before they presented
Don't
the,
confuse.
yes, before
Be
they,
fair.
yeah, Sure, my lord.
Be fair. This
Yes.
is not the same.
Before they presented the second check for.
That is not,
investment.
you argued that for the
Yes.
same sake, twice notices have been issued. This is not the case.
This is not the
Yes.
This is not the case. Earlier is 207, last is 06 and 07. And earlier was 03 and 04. This is 06 and 07.
exactly your
Yes.
lordship.
That's what I'm saying. He said only two procedure, but I am saying
Oh,
that
these are
49.
facts. These are facts.
And before they deposited the check for engagement, I have already informed them that the bank account has been closed. I have intimated them.
These are methods to be
Yes.
decided by the trial court. See,
Mhm.
difficulty is this, you have filed this unnecessarily. Now, if we dismiss this petition, we'll have to deal with the facts.
But my lord, may appreciate this. They have never served me even the complaint copy, not even that legal notice also.
Can that be a ground for setting aside? Quashing a complaint proceeding
Yes,
under
that is
138?
that is why I'm coming for that. CRPC 204 states that complaint should be accompanied with when serving the notice. I only received the summon issued by the CGM.
Okay, fine. Can that be a ground for quashing a complaint?
My lord, those are the grounds which I can, because they are
Can
not,
are there settled grounds setting aside a complaint?
they are not following the prescribed procedure, my lord.
They will follow it. They will give you a copy.
Now, after a long time,
We are dismissing it.
it's up to you, Lord. But my lord, if arbitration should go, may kindly direct to that way.
No, arbitration,
If they want.
party prefers, they can go for arbitration.
Hmm.
You could have raised an arbitration long back,
But-
saying that this was money not due to you. Then this would have been a dispute. Then you could have argued that arbitration is pending, whether it is due or not due.
My lord, actually, that is not due. It is a contract work and
It is not
will be-
your case that I have raised a dispute that this is not due. You raised the dispute before
Yes,
this.
even I have mentioned in my petition here, my lord.
Understand, why are you not getting my point? Under
Yeah,
482.
I'm getting it, my lord.
482, we cannot
Hmm.
go to the facts, determine facts which require evidence. First thing, your case is that this money that they have issued the check of 2 crores and all,
Mhm.
it is not due to them. Is that it?
Yes, it is not due to
It
them.
is not
Lord.
due to them.
Yes.
So therefore, if it is not due to them, whether it is due to them or not due to them,
Hmm.
is to be established by evidence.
Yes, my lord.
You will have to discharge your burden.
I got it, my lord.
Can that be done here? That cannot be.
My lord.
If that cannot be, we cannot make a determination that this is not due. So that you will have a forum, appear there and take the defense. Moment you can discharge your burden, preliminary burden, the burden will shift to them that they will have to establish that this is due. This is first. Second, otherwise notices all are in time.
No, I'm saying that, my lord. My argument.
Your argument is that
They have never served
these
me
are
legal notice.
checks, security checks or something like that checks I have given. There is no legal due. Not only these 2 checks, I have given many checks with my signature with good trust, but there is no due, enforceable liability.
And as prescribed by the NIA Act, notice has never been served to me, my lord.
Your lordship, just to apprise the court.
Notice is not served to it. This is also a matter of fact.
If notice is not served, how could they file a complaint? The law is very clear, my
No,
lord.
law is very clear. Without
Yes.
notice, there cannot be. But
Yes.
they had made a statement at paragraph, where is your statement? They have issued a legal notice on such and such date. You say that I have never received this.
Yes, they have never served me.
They have never
It is the
served,
purported legal notice.
never
my
served
lord.
you.
Yes.
That is a fact to be determined before the trial court.
Yes, my lord.
I think I am not been able to.
No,
explain myself.
I understood, my lord. I'm understanding. my lord.
If they say that this notice is not even served, now they initially they will have to prove these facts.
Yes.
Before presumption is taken against you, they will have to prove this, that this was the legal notice I issued, this was the receipt. If they fail, matter ends there. Problem is this, you are arguing all this, we'll have to address, then what will make a determination? Any determination we make may affect you before the trial court. When you argue, we'll have to deal with it. Isn't it?
My lord, in the earlier, this honorable court has even, it has said that even the fact of the case may be placed here before this honorable court. So I'm just placing the.
No, that's correct. Fact will have to understand. Fact will have to, but we cannot determine fact, which requires an evidence. That is the 482. Yes, even facts we can entertain when apparently we are satisfied that facts are admitted. That's why I went to that notice. If there is two notice for the same sake, then of course that's why I have asked what is his stand. If he disputes that no, this is not my notice at all, then we cannot decide. But it is an admitted fact that this notice was issued. Of course, we can say no, you cannot issue two notices after first notice period is over. Or a check is deposited after 2 years of the date drawn.
Yes.
Of course, you look into the check and say this was a check such and such date. This is the petition you have filed on such and such date. We can decide it. There is no problem on that. But here facts are disputed.
Actually, my lord, facts are not, in my opinion, facts are not disputed because I've already informed him that please return the check since the account has been closed. So after that only, they go on depositing another 2 checks.
Where is that? Where is your reply?
My lord, it is on page.
Yes.
Page 29. Here on April 17, 2021, I have communicated him that please don't use the check. The account has been closed. Knowingly, malafide intention, he has deposited check for engagement.
Now, what is your stand as regards this? According to you, this was issued on 17th of April 2021. And he issued the notice on 21/12/2021.
The account has been long been closed before he deposited the check, my lord. And I have intimated him on 16, I have closed the account. And on 17, immediately on the next date, I have informed him, please do not use the check. And then
When this account was closed?
16 April.
And his notice was issued on 21/12/2021.
Yes, my lord.
January.
Yes.
Notice was issued on January.
Yes, my lord.
Who knows that you have done this after receiving the notice?
No, my lord. Here, the account was closed on 16 April 2021. And now I have communicated him 17 April 2021.
Very nice,
on the
very
next
well,
day. Yes.
very well. Check was presented much prior to that.
No, not much. After that only.
No. It was on 21 notice. It was presented on 10/12/2021, isn't it?
Yes.
Yours, your,
Mine is April, my lord.
huh?
April.
April
Has
21.
deposited then, April, March, May, June, July, August, September, October, November. After I have communicated with him after 9 months, after
No, no.
4 months.
Please listen to this.
Yes.
SEC is dated 8/12/2021. Huh? Or 2020 or 2021?
21.
And 9/12/21. And you deposit, okay, you deposited the SEC in, you intimated in the month of April. Okay.
Your lordship, just a few seconds, your lordship.
Hmm.
They have admitted also they have a legal liability to pay the money.
Hmm.
Your lordship, this honorable court on 31/8/2023. 31/8/2023. This honorable court has directed both the party to sit together and amicably settle the matter.
Then what happened?
Yes, your lordship, this is the minutes of that meeting, your lordship.
That we cannot rely.
Yeah, we cannot rely, but
We cannot rely.
yes, your lordship.
That has failed or what?
Yes, your lordship, he said
That is failed or what?
yes.
If it is failed, we cannot rely
Yes,
on.
no, I'm just appraising
We
the
cannot even look into that.
okay.
There's no value of
Yes,
that.
yes, your lordship. Just appraising that they are saying that I have 1 crore to pay. So that was the dispute. So
My lord, that is gone.
No, that forget about
Yes,
that. That
yes,
we
yes.
can do.
My
That-
lord,
yes.
here I have communicated.
If it would have been concluded with a
No, it
both
can-
parties'
yes.
signature, then it is a different issue. We cannot rely on that.
yes, your lordship.
My lord, I have communicated him on 17 April 2021.
There's
Yes,
a confusion
deposited-
in my mind.
He has deposited the check 2012/2021.
What about their stand on that?
And we have a communication also, Lord, through WhatsApp, page 31, my lord. There. I have printed out through WhatsApp, through the phone, page 31. We have even have had communication. And explicitly, I have asked him to return, requested him to return the invalid check.
Take down. You take all this plea before the trial court. See, their affidavit specifically denied. Further, deponent categorically denies the statement in as much said that on 17/4/2022, the petitioner too has intimated the respondent number 3 was about closure of the bank account and invalidation of approach check and for return of the said check. Now we'll have to prove it. That it was issued, he received it. Moment you can prove it, you have a good case.
Oh, my lord. It is just they have received. Proof is there. 31, page 31. Personally, we have communicated this.
You are taking us to a court of determining facts.
I'm sorry, my lord. But actually.
Then we'll have to
that's
call that lady and put a box there and ask both of you to cross-examine.
Yes, my lord.
Hard. Learned counsel for the petitioner and also Swensu. The present application is filed under section 482 of CRPC. CRPC. For quashing the proceeding of CR case number 01/2022 pending for trial before the Court of Chief Judicial Magistrate, Dimapur, Nagaland, against the petitioner. Now, what do you say about any law that on 2204 non-adherence of 204 will vitiate the entire proceeding? Anything?
Not much, my lord.
Huh? No, any law, case law? that non-adherence of section 204 shall vitiate the entire proceeding. Can be ground of quashing. Anything you want to place?
No, my lord, since.
Full stop. The aforesaid complaint case number 01 of 2022 was preferred by the respondent number 2. Respondent number 2 against the petitioner alleging dishonor of two checks bearing number 402707 dated 8/12/2021 and check bearing number 402706 dated 9/12/2021. The basic ground of challenge firstly is that the contract that there was a tripartite agreement between the petitioner, respondent number, between the petitioner and respondent number 1, 2, and 3. 1, 2, and 3 for execution of certain work, and in terms of the aforesaid agreement, certain blank checks without date were handed over by the petitioner.
Post-dated check.
Post-dated checks
49 leaves.
for post-dated check of 49 leaves were issued and handed over.
Actually, it is not postdated.
Not come up. 49 leaves of post-dated blank checks.
Yes, blank check.
Post-dated blank checks were handed over to the
Complainant. Yes.
to the complainant. And
Representative of the complainant, my lord.
representative of the complainant, and the complainant has misused it and deposited the said checks before deposited in the bank account. In as much as there is no due, no legally enforceable due.
Yes.
Full stop. It is also contended that in terms of the tripartite agreement dated 4th of January 2018, under clause 5, there is a provision for dispute redressal mechanism between the parties through arbitration. And therefore, even if there is some dispute, the NI case under NI Act is not maintainable. Full stop. The further contention of the petitioner is that the procedure under section 204 of the CRPC has not been adhered, and the petitioner has not been served with a copy of the complaint petition, and therefore on this count alone the complaint case is liable to be set aside and quashed. It is further contended that what will be the other contention? That this is not negotiable due. And the further contention is that
Check has been presented.
further contention is that on 16th of April 2021, the petitioner closed the bank account as the same was not in operation since long. And on 17th of April 2021, the petitioner intimated the respondent number, intimated the complainant.
Yes, the
complainant regarding such closure of bank account and requested the complainant to return the check memo. And therefore, it is contended by the learned counsel for the petitioner that in view of such intimation, the deposit of the check on 21/12 the deposit of the checks on 8/12/2021 and 9/12/2021 itself is bad, and on the basis of a check which has been dishonored even after the knowledge of the complainant regarding the fact that the account has already been closed, comma. This is nothing but an abuse of the process of the court and to harass the petitioner, and therefore the complaint case is liable to be dismissed. Full stop. Per contra, the learned counsel for the respondent submits that the issues raised are disputed questions of fact, and such fact cannot be determined in a proceeding under section 482, inasmuch as the petitioner in their affidavit specifically has taken a stand that that the complainant has taken a specific stand that he or she was not intimated as regards closure of the account and no communication was served upon her. Therefore, full stop. The learned counsel further contends that having an alternative dispute redressal mechanism will not debar the complainant to go for enforcement of the legal debts by depositing a check and therefore such remedy of arbitration cannot be a ground for quashing and complaint petition. Okay. Rest of the part will dictate in the chamber. Okay. Dismissed. However, parting with the record, it is made clear that this order shall not influence the learned trial court so far relating to the issue raised in the present petition, or that may be taken by the petitioner during the trial of the case of the trial of the CR case number so and all legally available defense shall be available with the accused petitioner, including those that has been taken in this petition. You take those defense, you prove that document that it has been served, matter ends there.
Sure, my lord. I know, placement.
For admission, item number 23.
Dismissed. Send this to the chamber. Yes. Let us see the act first.
Lordship.
That is the amended and the latest one. Paragraph 2, Lordship will find amendment of section 3 of the Nagaland Retirement from Public Employment Amendment Act 2007. The existing entry shall be substituted by the following section 3 clause 1. Notwithstanding anything in any role or orders for the time being in force, a person in public employment shall hold office for a term of 35 years from the date of joining public employment or till he attains the age of 60 years, whichever is earlier. Section 3, clause 2. A person under public employment shall retire on the afternoon of the last day of the month in which he attains the age of 60 years or
was
in which
amended
he
when?
completes 35 years of public
This
employment.
was applicable when you were sent on retirement.
And the definition of public employment, Lordship will find it. Section 2.
I think
clause
we
1.
might have a book in
Yes.
the chamber.
Nagaland Code Volume 5.
Volume 5. volume 5, no?
Micro one, this
This
one,
is 3.
for reference, you can take.
Okay, we'll find it out. Let us see.
Lordship. As per the definition,
Hmm.
appointment to any pensionable public service or post which counts for pension.
Okay.
So the basic fundamental of pension rule is there should be continuity in the service. Then only it can be counted for pension. After the act has been passed, after it has been amended, several cases came up before the Honorable Court.
Hmm.
There were a lot of litigations
Hmm.
with regard to the interpretation of the definition from which date it has to be counted.
Hmm.
And in few cases, this Honorable Court has arrived to a finding that even the contract ad hoc employment can be counted so long as there is no break in service, so long as there is continuity in service. Therefore, few
So
notifications have been issued.
here issue is basically whether your service during the contract period initial should be counted or it should be counted from the date of regularization.
No, not exactly on that, Lordship.
Ah.
My contract service, a part of my contract service was also counted,
Hmm.
and I also admit that.
Hmm.
Because from that date, that is 17th of November 1989,
Hmm.
there was continuous service,
Hmm.
and prior to that, since there was some break
Hmm.
gap, that should not be counted. That is starting from the 88.
Hmm.
That should be excluded. But from the period from where there is continuity in service, as per the standing government memorandum and the act, my service should be, length of service should be counted.
According to you, not the entire contract period,
Yes.
but the contract period which is in continuous, that
Correct.
is continuous, that should be counted.
Yes.
Okay.
As per the definition of the Public Employment Act
Hmm.
and as per the standing government office memorandums.
Hmm.
There has to be continuity. I agree.
Hmm.
Yes. In order to get pension,
Hmm.
there should be no
What
break
is the
in service.
pensionable period of service?
Pensionable period of service is
What is-
20 years only,
20 years.
after 20 years. But then for the purpose of retirement,
Hmm.
35 years, 60 years, whichever is earlier.
Earlier.
And to count that,
According to them, you had your 35 years of service. On the date, they have asked you to go on return.
yes, Lordship.
Taking note of your initial
Yes.
appointment.
Yes.
Suppose, according to you, what should be your date? That date, there are some breaks in some
Yes.
orders. There are no condition.
Yes.
From the date when it is continuous.
It is from 17/11/1989.
17/11.
1989. So as per the act, it should be the last date, that is 30th November 2024. On that day, I complete 35 years.
What is your age?
My
When
age-
will you attain 60 years?
60 years will attain. My age is only 54 now.
Only 54.
Going by that, I will serve, I will have so many years to serve also.
What is this office memorandums?
That is, Lordship is referring to which memorandum? All the office memorandums are pertaining to counting of contract ad hoc services, but
Oh.
for easy reference, Lordship, Lordship, may kindly come to paragraph 6. The,
That office memorandum 29th March 2017.
yes. This has been superseded already, so may not be relevant. 4th May 2017. Here also paragraph 6 will be relevant.
Paragraph 6, dear petitioner, period of service rendered on ad hoc contract workers substitute period, which is followed by regularization or regular appointment without break or gap.
Yes, that is important. There should be no break or gap in the service.
So, period which is followed by regularization. So, it will be counted continuous service from the date when you are regularized.
There are
Back.
two things, Lordship.
Ah.
Contract ad hoc service followed by regularization or regular appointment.
Okay, regularization. Suppose this point is a point of regularization. You have started in that point. There are certain grapes.
Yes.
But your services will be counted from the period which is continuous to your regularization.
Exactly, Lordship. Yes.
Isn't it?
Yes.
Which is continuous to your registration.
Yes.
It may be continuous from day one,
Yes.
the last break.
Yes.
From the last break to your regularization.
Yes.
That is, which should be a link between the last extension
Yes.
and your regularization.
Yes.
So last continuous service from the
Yes.
regularization.
Exactly, Lordship.
Isn't it?
Yes. So that is in my case, 17 November 1989.
Okay.
And all along, the government have been taking that date.
Okay, then which is this is 4th May 2017.
Yes. And again, another interpretation of that, another OM was issued in 2017, 31st August 2017. This is also with regard to the counting of contract ad hoc work charge substitute for the
Okay.
purpose of retirement.
But same
paragraph.
Same
Yes,
paragraph.
same principle has been followed. Therefore, from here, we can gather that there should be no break in service. In other words, there should be continuity in service, so as to treat the service as pensionable service under section 2 of the Act.
Okay. These were issued in terms of certain judgment of this court.
Yes, yes,
So therefore, this is your case.
yes. And Lordship, kindly come to the website of the PNAR department, which is the nodal department.
Where do you get that?
Page 69. Last page. Government of Nagaland has introduced PIMS. And then on the basis of that, the PNAR has prepared this. We are concerned with serial number 3, the bottom, Lordship. Law so-and-so, name is shown, Surjit Singh. And then department is Law and Justice Department. Designation is
1711.
UDA, Directorate. And then Office, Secretary, Justice and Law Department. Now it has been changed to Law and Justice Department. And then on the extreme right, Lordship will find TOG, date of joining. That is 17/11/1989. This has been corrected by the PNAR in the website after filing the writ petition, Lordship. Date of filing the petition was 29/8/2023.
Just a minute. Let us see your first, your appointment and extension order. First is at
Yes, Lordship.
2/8/1988. Is that it? Initial.
Yes. Page 26, Lordship, I would like to emphasize on one point here.
5110.
Page 26 is the type copy of the extension order. And
Page 26. Huh?
yes, this is 26 September 1989. Extended under the same terms and conditions till 31/10/1989.
Hmm.
So
There was
this-
a break till 17th of November.
so as per this extension order, the service ended on
So
31/10.
by 17, according to you, it is till until further orders. Earlier
Yes.
it was 4 months and first one is a 4 months. Then second one is to up to a date
31/10.
10 and
89.
31/10/89. And third one is until further orders.
Yes.
Hmm.
So since there was a break of 16 days between the extension order of 26 September 89 and 17 November 89.
So you were regularized on 2002 with effect from 3/3/93.
Yes.
So up to 3/3/93, you continued in terms of order dated 17th of November,
Yes.
November 89. Therefore, this was the last continuation prior to your regularization
Yes.
on 3/3/1993. Okay.
Yes.
We date this 3/3/1993.
Yes.
It was
Effective
regulation.
date.
It is
But although regularization was made effective from 3/3/93, service will be reckoned from
in
17
terms of the
November.
continuous because of that was the last continuous.
Yes.
service.
Yes.
Okay, this is your case.
Yes.
So therefore, your 35 years to be calculated on the basis of your entry into service on 17/11/1989.
Yes.
This is your case?
Yes.
Yes. What is the government's case?
Government.
We are taking from the date of the entry. Your lordship, there is no gap, your lordship. We are saying that there is no gap because no salary has been disturbed, your lordship. Now, your lordship, the extension order, it clearly says that in continuation, your lordship, that is in continuation of the earlier extension order, your lordship.
See, let us see. That is the vital
Yes,
thing.
your lordship. At page 28 is the type copy, page 28 of the repetition, your lordship.
First is for
continuation.
4 months
Yes, yes, your lordship.
till
Till
4 months from 1988.
yes.
Okay.
Till 31/10/89, your lordship. The second, the first extension
No,
order,
no, there is a defect.
your lordship.
His service was 4 months from 28th of July June 1988. At 4 months,
Your lordship.
July, at page 24.
24.
Uh,
Yes, your lordship.
July, August, September, October, November. Isn't that it?
Yes, yes, your lordship.
Now,
September.
So page 24 is
July,
the initial appointment,
July,
your
August,
lordship.
September, October. Okay. On 26th of September,
Yes, your lordship.
it was extended till 31/10.
Yes, your lordship.
Okay.
Yes, your lordship. That is in continuation to the initial appointment, your lordship.
On 26th of September, this is done 31/10.
Till, yes, till 31/10/89.
Till a specific date.
Yes, till,
Till.
yes, till 31/10/89. Your
But-
lordship, the extension order was issued on 11 November and the petitioner is taking
17 November.
17 November. Yes, your lordship, and the petitioner is taking this date. It cannot, your lordship. Because the order, it clearly says that in continuation to this department order of even number dated 26 September, your lordship, this is the early extension order date. So this order, this extension order cannot be the basis for content of the service, your lordship. There is no break, your lordship. And your lordship, the joining report itself is also unequivocal, your lordship.
Just a minute.
Yes, your lordship. It may be immediate, it may not be immediate to issue the extension order, your lordship. But it is in continuation.
According to you, this is an ex post facto extension.
According to the petitioner, according to us. Your lordship.
Yes,
Yes, your lordship. It can be.
It is an
yes.
ex post facto extension.
Yes, because the salary of the petitioner was never disturbed, your lordship. And he continues without break.
So according to you, this in the all the letters
Yes,
after 1st to 2nd of August, in 26th of September, you continued in terms of 1989.
yes, yes.
Where is that 1989?
No, there is no 1989.
It
your
should be
lordship.
288888. In continuum of his department's order event dated 8989. What is that 18989?
8989.
1989.
There is no
This will-
order of 1989.
Ah.
I have tried to locate this order. They are the custodian of the records. If they can, let them show also, but there is
See,
no order.
what is discernible from this record is the petitioner was temporarily appointed for 4 months
Yes.
Yes, yes,
Mm.
yes.
in certain scale of pay with effect from 26/1988,
Yes,
28th of July 88 for 4 months.
Yes.
yes.
So when 4 months will be over?
August, September, October, November 2nd,
November 28.
88.
Effect from
Huh?
2nd November
No,
1988.
4 months.
Yes.
4 months
From
will expire
September
Of course.
to the
20,
month of October.
not 2nd,
September.
28. 28th of June.
July,
No, this is second,
October 28th, it will expire. Till
Twen-
October 20,
28,
no, 20,
28.
20,
20, yes,
20, 10,
10,
88.
88, it will expire. So
Expire.
before the expiry, his extension was given 26 September 89.
26,
September
9, 26, 9,
89.
89.
Or even if we go by the the order of even number dated
So
19.
26/9/89 extension was given
Yes,
in continuation,
to this department
one order.
dated 1
in
9
continuation of
of even
1989.
Yes, yes.
Now therefore, what is 1989?
Yes.
So your lordship, this must be
See,
the
let
order.
us, what is 1989? Because
Yes.
his appointment was on 20, 28/6, this order was 1888.
Your Lordship, there is no order as such one.
Order is,
Yes. Down below
huh,
at page 24.
1888.
That is why it is shown as 28 occurs 88 on the top. In the bottom, it is shown 18.
1888.
It should be the date of issue of
Date
that
of issue.
order.
Date of issue.
Yes.
In my copy, there is no number.
Okay. Okay, we'll come to that later. Huh? Then second was so according to you, these are the continuous orders.
Continuous, yes.
Continuous orders. So therefore, his entry will be on
Counted from
2nd of. Entry will be from 28 of 6, 1988. And
yes.
his 35 years will
will be over on 36/20/23.
36/20/23.
2023. Yes, Your Lordship.
Okay.
Yes, Your Lordship.
And for the time being, Lordship,
As
may can
for-
kindly come to page 64 of the writ petition, Annexure T. This is the tentative seniority list issued by the department.
64.
64 years. 6 July 2023.
Hmm.
This is issued by them. And I have been made to retire with effect from 30th June 2023. And Lordship, may kindly see the last line in page 64.
17/11/89.
If no representation is received within the stipulated time, this tentative seniority list shall be treated as final. So it has to be treated as final. And come to next page. This is the case of the petitioner, page 65. Seniority list of LDA, UDA, HA under the Advocate General establishment. Because establishment, your Lordship is well aware, Advocate General establishment is a very small establishment. Station at Gauhati. There,
In the aspirations,
on-
in the aspirations of promotion, you have been released.
31/4/2023, name Surjit Singh, designation HA, date of birth 9/10/1969, office, Advocate General Office, Gauhati, date of entry into service 17/11/89. Very clear. And in their own order, they have stated that if no representation is received on the tentative seniority list, this will be treated as final. So it has become final. And after the final, what next? Nothing is left. Date of retirement is also shown as 30/11/2024.
Your Lordship, regarding that, we have to make a reply at para 11 of affidavit that the date has been wrongly entered, even in PIN. So that has been ratified, Your Lordship.
Affidavit
Yes, Your
cannot
Lordship.
improve the case.
No, Your Lordship.
The
the
business-
Your case is, to summarize, your case is that whatever the date reflected 17/11/1989 is against the principle of continuous service. And in this case, his service is continuous from his initial
Yes,
appointment.
yes, yes.
And therefore, the date is to be
Counted from the date.
counted in terms of the act and the notifications
Yes.
issued thereon,
Yes.
not on, and therefore you will have no right even if it is wrongly reflected in some documents.
Yes, yes,
This
Your
is your-
Lordship. Yes, yes, Your Lordship. Yes.
Anything, Shamir, to add?
Lordship, that is my simple case.
And
Okay,
in fact, Your Lordship, the
Because,
petitioner is contradicting
Lordship-
his own statement. In WPC 189, they have filed for financial upgradation. There also, he has made a clear statement that his initial appointment was in the year 1988. That I have annexed in my affidavit. also.
Okay, we'll dictate the order tomorrow,
Lordship.
because in presence of you, I will dictate,
Lordship.
so that I do not commit a
Lordship,
mistake. Let me think over it.
Yes, your lordship.
It's not that you have also made out a case. Think over, Jamis. Think over. I am also thinking. The second principle, which should be, on what basis it should be counted.
Yes.
We are guided by this latest office memo.
But your MO will be applicable on the date when he was retired, not new. Will not go to that. Isn't it?
If it's
Whatever, you can give it to me,
Yes.
but whatever decision you have taken,
Yes, yes.
it must have been taken on the notification holding the field on that day.
Lordship.
And if I'm to retire under normal circumstances, as they are saying, then I should be given at least few months' time to make preparation to go for pension. That is the rule. Now, on a retrospective date, they have issued.
That's 6 months notice.
Yes, after conclusion of all the litigations.
I'll just go through the facts tonight and come back tomorrow. Just take a note, what are the facts.
And we have file reply also.
We'll go through the everything. Please this matter tomorrow.
Applies.
No, that is not acceptable. That's popular. But I think we'll be making this one. Huh? But he's going to go to this one. Then are you going to go somewhere? Oh, that's going to go through. What could we say?
Yeah.
This oh. Bring one na. Hindi siya iba. Yan ba ko? Bring one.
23 items, you have to call it by slip tomorrow. You have to call tomorrow by slip. By slip? By slip. Utusan dari Hai.
We pass over the to cost this scenario.
Ada.
Pass over kalau clear na.